Good morning, loyal opposition. Good morning. Good morning to the people of Barbados. We are here in this march today because we are opposing a section of the wiretapping bill entitled 52B. I want you to remember that section, 52B. This is the section that gives law enforcement officers the right to intercept, the right to invade your privacy without any prior. And I want you to understand the meaning of the word prior. Prior means that they can enforce this legislation, if passed, without seeking a warrant. What concerns us is that even in the United States, where terrorism is prevalent, mass shootings prevalent, drug activity prevalent, cartels prevalent, even in the United States, the FBI, law enforcement, nor the CIA can intercept a single communication of a citizen without prior warrant approval of the judiciary. I put it to you that if in America that is required, certainly Barbados does not face the same level of violence, the same level of terrorism, nor matters of national security at the level of the United States, where they demand prior knowledge. For you to get a warrant, you have to specifically name the areas that you wish to address. None of this is specifically named in this bill. As a result, this 52B must be removed. And I want you to understand that according to the Constitution of our country, this is a blatant violation. For anybody to stand in Parliament, regardless of the name they are called by, and tell us that this has been going on for years, I am going to put all the attorneys on notice whose people they represented are now in prison because of any form of surveillance. Now they should appeal those conditions and call for retrial because that evidence was collected illegally. Every single Prime Minister prior to this one has indicated they have not used it. Now I can't tell you whether they're telling the truth or not, but they have denied use of it. Yet we are told by a member of Parliament, and I want you to understand what we are saying. A member of Parliament. Parliament is one of the highest aspects of representation and legality in this country. And as a result of that, a member of Parliament is going to indicate that they have been doing this wiretapping for years without surveillance. This is about Section 52B in the wiretapping legislation before the House, the interception bill. That is what it's about. If you are within the sound of my voice and you have a cell phone or a tablet or a computer, what this bill is saying is that government can intercept all of your communication without your consent or without any judicial approval prior to their interception. No warrants. This is a serious violation of not only the Constitution of the country, but also international legislation. And I read for you, and I quote, the Inter-American Court of Human Rights stated that it condemned warrantless interception and emphasized that surveillance powers require strict prior judicial control. That is the Inter-American Court of Human Rights. Secondly, the European Court of Human Rights rule that prior, I want you to ring in your ears, prior authorization by an independent body, not one appointed by the minister who is overseeing the legislation, an independent body, is essential to prevent abuse, and post facto approval is sufficient. They mean fundamentally that there is no facility that makes it right for the government to have access to your information without a prior warrant. That is section 2B, which has the 5.2b, which says different. What 5.2b says is that law enforcement of any kind, whether it be the police, the defense force, or any other form that the minister chooses to install, can access your information without your consent, without your knowledge, and without your approval. That is illegal under our Constitution. So we are asking, no, we are requesting, no, we are demanding that the government removes this section from the wiretapping bill. Section 5.2b must go.